Says Michael Popok, LegalAF. Motive is always the centerpiece of fictional trials on television or in the movies. What's the motive? We'll tell you about his motive. What was his motive? To the ladies and gentlemen of the jury. But in real life, in real prosecutions and defense, motive is not an element of any crime. It's not a motive of any element of any crime that Donald Trump has been charged with or any of the rest in the 91 felony counts, in Mar-a-Lago about the documents or anywhere else. But it does go a long way to helping create a cohesive narrative for the jury to understand as they're evaluating all these disparate pieces of facts, evidence, and testimony. And so it does keep prosecutors up at night to try to explain motive. So while it's not an element of a crime, it becomes an important overlay, a tool for the prosecutors to put on their case. And oftentimes the defense will say, there was no motive. What was the motive? Why would he do it? Now, the facts in Mar-a-Lago are basically undisputed. They're undisputed. Donald Trump did not return dozens and dozens of boxes that contained national defense information material and at least 30 classified documents. That's not in dispute. He hid them from the FBI, from the lawyers for the Department of Justice, from federal judges. He hid it from his own lawyers. He used his staff. Molly Michaels, his executive assistant, Walt Nauta, his butler, the head of maintenance, Carlos de Oliveira, and the head of his IT department, Yuscil Taveras, to help him hide the boxes and moving them around like a giant shell game within Mar-a-Lago to keep them away from the government at every turn, and from his own lawyers so that they could lie to the government, maybe unwittingly. That's not in dispute. You might want to get into the, arcane, what was the DNA of that document? Was that really national defense information? Is that really classified or not classified? Sure. But the facts are the facts, and they're immutable. Now, Donald Trump has basically argued that he's just a pack rat. He's a hoarder. I just kept everything. I'm sorry. It was a mistake. But of course, that's inconsistent with the timeline of actions and activities and conduct led by Donald Trump to hide the docs and hide the boxes from the government at every turn. National Archive, Department of Justice, FBI, federal judges, magistrate judges. That's why they had to execute the FBI search warrant, right, without announcement to go pick up all the documents. Now, the prosecutors believe, having looked at over a year of information developed in investigations of a non-classified nature, including interviews that they've conducted, including video surveillance footage that they have, that they can answer the question, though, that the jury will have on its mind about what was the motive of Donald Trump. And I know that because in a most recent filing by Jack Smith and the special counsel down in Florida, in their response and opposition to Trump's motion for adjournment of trial date, third attempt by Donald Trump to get the trial date out of this current May of 2024. He's been trying to get that trial date not set or moved since he was first indicted. He tried to argue to the trial judge, Judge Cannon, don't set a trial date at all. It's too early. She rejected that. She instead set the trial date before the elections, which is what the DOJ, Department of Justice, has wanted. Then he said, the Department of Justice screwing around with documents. We got to build a whole facility to look at six documents, and we should have a delay. And the judge says, I don't see that right now. I'll kick out some deadlines, but we're 7 months away from trial. Plenty of time. Plenty of time. I mean, Senator Menendez for the Democrats is going to trial in like 4 months in a elaborate bribery scandal. And he's going to trial in less than 6 months from when he was indicted. Federal cases can move quickly. The government dumps everything they have. The defense reads it and analyzes it. They put on their witnesses. The defendant often doesn't testify, and a jury returns a verdict. It's not that hard. It's not that hard. So he's been trying, and he slips it in, Donald Trump and his lawyers, at every turn and every footnote. You got to look carefully. He's looking for an adjournment, a continuation, a cancellation of the trial. Of course, he gets caught by Jack Smith every time. And so the recent filing that just got filed just 2 days ago, this is what the government says about they figured out motive. And I'm going to read it to you because I think it's really fascinating. This is on page 4, over to page 5 of their motion. It says, for the Section 793 counts, that's the Espionage Act, Trump is of course entitled to classified discovery in order to test or challenge the government's proof of the elemental allegation in the indictment that the documents he retained at the Mar-a-Lago club contained national defense information. Government says that's legit for defense. But the fact is, the brief goes on, the great majority of the allegations in the indictment, including allegations of the defendant's conduct, knowledge, and intent, we're coming up on motive now, turn on evidence contained in the unclassified discovery, not the much smaller set of classified discovery. So remember, even though Donald Trump hid dozens and dozens and dozens of boxes, there's only 30 classified documents. I mean, you can tell I'm getting a little fatigued. Only one is enough. One would have sent you to the electric chair back in the 50s, okay? He had 30. In addition to that, he had a whole, to use his phrase, his vernacular, a whole pile of other materials, including about the Iranian war plan that he kept with him and took with him to places like Bedminster golf course, where he showed him off to his friends and family over a Diet Coke. I am not making any of that up. Okay, the government says we can prove intent and ultimately motive, how it occurred, why it occurred, through non-classified documents that have all been produced to Donald Trump. That includes witness testimony. And I'm going to talk about the witnesses and the evidence I think they already have. And the motive I think they already are ready to establish. And the one that they're not, I'll be fair. But the brief for the government goes on. That the classified materials at issue in this case were taken from the White House and retained at Mar-a-Lago is not in dispute. An immutable fact. What is in dispute is how that occurred, why it occurred, what Trump knew, and what Trump intended in retaining them. Aha, motive. All issues that the government will prove at trial, primarily with unclassified evidence. That includes witness testimony. Whether the highly classified documents Trump retained at Mar-a-Lago contain national defense information, which goes to the Espionage Act, is a fact Trump can try to dispute, the government goes on to say. But it will hardly be the centerpiece of the trial. In other words, the centerpiece of the trial is obstruction. Obstruction of justice. The hiding of the boxes, the documents, from Trump's own lawyers from the National Archive, from federal judges in Washington, from the Department of Justice's lawyers, from the FBI. That is the centerpiece of the case. Go back and watch Merrick Garland announce the appointment of a special counsel, Jack Smith, in the case, and including for Mar-a-Lago. He mentioned obstruction half a dozen times. He mentioned the Espionage Act not once. It's always been the focus of the trial. It'll always be the focus of the trial. This is an obstruction case, and the conspiracy around obstruction and the conspiracy to destroy evidence, that's the trial. As a side byproduct, they'll put on a case about Espionage Act. But the focus of the case from the opening bell, the opening statement, is going to be obstruction. And we just have another confirmation of it here in the Jack Smith's recent filing. So to repeat what they've argued, whether the highly classified documents Trump retained at Mar-a-Lago contain national defense information is a fact he can try to dispute. But it will hardly be the centerpiece of the trial, i.e., we're trying an obstruction case. Regardless, as discussed below, none of the defendant's claims about the availability of classified discovery justifies a continuance, and they go on. Let's talk about motive and intent, which now, in a very bold and, dare I say, brazen fashion, the Department of Justice has told the world they're ready to prove. Let's start with what it's not in terms of motive. Originally, the Department of Justice thought that what Donald Trump, ever the business person, corrupt as he is, was trying to do with the retained information was trade it in the future. Trade it. Trade it, barter it, use it as leverage in negotiations for business deals or otherwise. He had a whole batch of documents against the Saudi Arabians. He's going to use that in his negotiations, let's say, for the golf tournament, right? For live golf or live golf, whatever it's called. He's going to do that. He's going to use the documents he kept about the French prime minister and his affairs or whatever was in that box against him in negotiations with the French, and so on and so on. A lot of it in the Arab world, because that's where Jared Kushner, son-in-law first son-in-law has gone to collect $2 billion in Dubai and in other places, and the Arab Emirates. So maybe they thought, working theory, the motive, the intent to keep the documents was financial, right? Avarice and greed, always good motives. And the government did search warrants. We talked about them on LegalAF right here on the MeidasTouch network and on Hot Takes, tried to get documents and information and all of that, and it sort of went nowhere. I know it went sort of nowhere because it got stubbed out and it doesn't exist, and it wasn't alleged in any of the indictments, either the DC indictment or the Florida indictment. So sort of was a dead end, as they like to say in the prosecutor world. But they got a gift, and it is reflected in the new superseding indictment at Mar-a-Lago, and that was the Bedminster audio recordings made by a ghostwriter for Mark Meadows' memoir book he was going to write about himself that Donald Trump participated in and held court. Interesting turn of phrase. He held court with these non-governmental, not classified people who didn't have security clearances at Bedminster Golf Course, right? Where he lives a lot of the time in New Jersey. And that is where we had the audio, and I'll play it for you again here next, which shows up in the indictment, where Donald Trump bragged about retaining a pile of documents that he just found in the pile of documents that he illegally retained, Iranian war plans related to then Chairman of the Joint Chiefs of Staff, Mark Milley, and to try to embarrass Mark Milley and to use it for his own personal advantage and gain in discussions and conversations as he campaigned for office. Look, I didn't want to go to war with Iran. This was Milley. Look at these war plans. Look at this. Look at this. That was him. That wasn't me, right? Let's play the clip, and then we'll come back and talk about it.
These are bad, sick people.
That was your coup, against you.
It started right at the
beginning.
When
Milley's talking about, you were going to try to do a coup. No, they were trying to do that before you even were sworn in.
That's right.
Trying to overthrow your election.
Well, with Milley, let me see that. I'll show you an example. He said that I wanted to attack Iran. Isn't it amazing? I have a big pile of papers. This thing just came up. Look. This was him. They presented me this. This is off the record, but they presented me this. This was him. This was the Defense Department and him.
Wow.
We looked at him. This was him. This wasn't done by me. This was him. All sorts of stuff. It's pages long. Look. Wait a minute. Let's see here. Look at that.
Yeah.
I just found, isn't that amazing? This totally wins my case,
Mm-hmm.
Except it is like highly confidential, secret. This is secret information. But look at this. You attack, and
Hillary would print that out all the time,
she'd send it to Anthony Weiner, the pervert.
Please print.
By the way, isn't that incredible?
Yeah.
I was just saying, because we were talking about it, and he said he wanted to attack Iran and what? These are the papers. This was done by the military, given to me. I think we can probably, right?
I don't know. We'll have to see. Yeah, we'll have to try to
Declassify.
figure out
See, as president, I could have declassified it. Now I can't, but this is classified.
now we have a problem.
Isn't that interesting?
Yeah.
It's so cool. I mean, it's so, we here I have, and you probably almost didn't believe me, but now you believe me.
No, I believe
it's incredible, right?
No,
hey, bring some Cokes in, please.
So there's Donald Trump, of course, once again, showing classified national defense information and other top secret documents, including Iranian war plans, to just people sitting around his office at Bedminster over a Diet Coke. Okay? And he did it because there was a motive. We know the motive on that one. And that's why he's gone after Mark Milley and try to attack him and call for his assassination, because he's going to testify against Donald Trump. And because Mark Milley gave an interview to the New Yorker magazine that was just a month or two before Bedminster, and that audio recording where he said, I called my Chinese military counterpart and told them we have a hand, the military in America has a hand between Donald Trump and the button for the nuclear option. Don't worry about it. We're not going to let him start a war with China. And he didn't like that. Donald Trump didn't like that. And so he decided to attack Mark Milley with a group of friends, like a parlor game. Except in this parlor game, he pulled out top secret classified documents that as the former president, he was not supposed to have, nor show it to other people who don't have security clearance. And so that crystallized for the prosecutors, as indicated ever so slightly in their filing, that they know what the intent was and the motive was for Donald Trump to keep the documents. Not that he's a hoarder and a pack rat and it just all got confused at the way out during the chaotic last moments in the White House while they were busy trying to overthrow democracy. They just didn't have a time to inventory and pack properly. That was sort of one of the arguments that his lawyers brought out early on. You know, of course, it all fell apart after the government got the testimony of Molly Michaels and videotape of Walt Nauta and Carlos and Yuscil Tavares trying to figure out how to move boxes and documents around, and all the other testimony of people involved, including Evan Corcoran, the lawyer for Donald Trump related to Mar-a-Lago, who had to turn over his 50-page single-space notes, deepest, darkest secrets of the attorney and the client relationship, because a federal judge found it was more likely than not that Donald Trump and Evan Corcoran were participating in a crime or fraud related to Mar-a-Lago. So the government now, the working theory now for the Jack Smith, obviously, from the non-classified documents and testimony of witnesses, is that Donald Trump kept the documents in order to gain leverage and advantage against his political rivals, in case he was ever prosecuted. When he ran for office and somebody said something out of turn, he kept a Hillary Clinton pile. In case Hillary started bashing him again, then he could go in and pull out his little secret documents and start reading from them, which makes a lot more sense, frankly, than he was a pack rat and a hoarder that did it by accident, or even the financial part. I don't put anything past Donald Trump. You know, maybe he just didn't get around yet to selling the documents for cash or using them in a bargaining position for commercial basis, a commercial business transaction in order to get an advantage and get money or to extort somebody. So I don't want to leave him off the hook and say, well, he would never do that. I just don't think I think he ran out of time. He just didn't get around to doing that, tied up as he is with his civil and criminal matters and trying to run for the Republican nomination. But they at least have him dead to rights on Bedminster, and an example of why. And they're going to play that for the jury in Mar-a-Lago. Some of you may be wondering, they will say to the jury in the future, why would Donald Trump do it? Why would a former president of the United States with nothing to gain and everything to lose hold on and clutch in it between his white little fingers? Top secret classified documents, national defense documents. Why? No other president has done it intentionally. Why? Well, here's one reason why. And they're going to play the Bedminster audio I just played you. And they're going to go back and tell the jury, see, that was Donald Trump using for political advantage and gain, and to take on his rivals and take out his rivals like a good mob boss that he was, holding on to packages of material, right, for his own use that he could then use to bash future witnesses like Mark Milley in any criminal prosecution. Because look, Donald Trump knew in the back of his mind it was possible that he would be criminally prosecuted in New York related to his business dealings, because it had been threatened for years, for 5 years going with an investigation, for Stormy Daniels in the hush money cover-up affair. And he also got counseled by his own lawyers in the White House that things that he was doing leading up to and beyond Jan 6th and the cling to power could be criminal in nature. I'm sure he heard it from Eric Hirschman, his deputy White House counsel. So Donald Trump knew it was possible, and he said, crap, I better download and hold on to some of these things. So I'm sure they're going to argue to the jury it was both to give him a leg up on a possible defense and go after witnesses that went after him, and for his own political gain and ambition, which makes perfect sense and gives something the jury can hang on to. Because I presented, the longest jury trial I ever did as a trial lawyer was 6 weeks. It's a lot of information for a jury to process, a lot of witnesses, a lot of pieces of paper. And you have to give them something to hold on to, like a life preserver, a life raft. You have to give them something. And you have to be they have to be confident in you as a truth teller, as an honest person, as a lawyer, to guide them through the process. So when I go up to this podium and I talk to my jury, they'll say, oh, I want to listen to Michael Popok because he doesn't mislead me. He takes me down the right path. He gives credible, intellectually honest explanations for things. Yes, he's an advocate. Yes, he's got a client to represent, but I can trust what he says. I want judges to feel the same way about me. When I tell them that a case stands for a certain proposition, I want it to stand for that proposition, and they can trust me that it does, because I don't mislead them. And if I don't know the answer to something, I'll say, Your Honor, I don't know the answer to that, but it's something, if you give me overnight, I'll come back and we can have a more coherent conversation. And they will say, that sounds good, Mr. Popok, we'll talk tomorrow. That's what happens when you have good lawyering, client advocacy in a courtroom. And so this is why the motive becomes important. It's a little bit of a glue that holds the story together, especially for a lay jury that's not used to being a jury. They saw, dozens of episodes of Law and Order, where they saw, or every movie that's ever had a closing argument or an opening statement, but that's not the same thing. Anybody that's served on a jury knows that's not the same thing. And so that is the most compelling thing that came out of this filing by the government, which, yes, also had a recitation of all the ways they've complied with their discovery obligations and how they've turned over 95% of everything. And we're only talking about 9 documents out of 30 that matter unclassified. And we're 7 months away from trial. There doesn't need to be a delay, because they got to cut this judge off at the pass, because it looks like, to an outsider watching this judge bob and weave and frequently side with the defendant, it looks like she's building a case to grant a delay request, not now, but in the near future, maybe 2 or 3 months from now, saying, well, there was, the government was laid on this box of documents and laid on this document, and it's undermining the due process rights of the defendant, so all bets are off. Now, we may be wrong. This might just be the judge pressuring the Department of Justice to kind of hold up her end of the bargain, make sure the defendant is treated properly, because, remembering the burden is on the government at trial. But she's not going to move the ultimate date, because one thing she did implicitly, because she had a chance then, was to put the trial beyond November. Just say it's a complicated case, a lot of moving parts, a bunch of boxes and documents. I'm going to put the case in and then 2025. And there would have been a lot of groaning. Democracy would have groaned, because now we don't know in this particular trial whether Donald Trump is a criminal or not. And that's something I think it's important for the American people to know when they go in. It's okay if they want to vote for him, but they should know they're voting for a convicted felon. So she didn't do that. And we were all sort of, pleasantly surprised that when she set the original trial, she chose a spring of 2024 date, not a fall winter of 2025 date. And so that was good. So I'm not so sure yet that she is going to move that date, but certainly all of her micro decisions leading into it is indicating that it's not going to be hard to just go and get her there and have her push the trial off. Now, the case in Mar-a-Lago, frankly, is not that complicated. And that's why you can try really not that complicated federal cases in 4 or 5 months' time. The amount of time that's left between today on this hot take and the trial that's scheduled is more time just now to try the case that would be necessary. You could probably try this case and get it ready with under 5 months to go. This case has been kicking around now for 3 months. So there's enough to try 2 Mar-a-Lago cases in the same time period, not just one. That's why Senator Menendez is going to trial so fast in a relatively straightforward bribery case. His bribery case is no more complicated than the Mar-a-Lago case. They went to his house. They opened up Menendez's refrigerator. No, that was another corrupt guy. They opened up his coat pockets in his suits that were hanging in the closet, and there were money stuffed in there. And they found hundreds of thousands of dollars. And then they found a few Egyptian-American and Egyptian business people that his new wife put him in contact with. And then he became an Egyptian lobbyist without being registered. And then he got kickbacks of Mercedes and money and gold ingots and all of that. And that's not that complicated of a case. It's about as complicated as Mar-a-Lago. Mar-a-Lago, there's a bunch of documents. That's the gold bars and the money. There's a handful of witnesses, same handful of witnesses as the Menendez trial. Some of those documents have to be looked at in a special facility, but you got 7 months to do it. So comparing and contrasting, the Department of Justice is like, I don't know, Democratic senator, we're going to trial in 5 months. Let's go. And you don't hear any due process complaints over there. Trump, can't possibly try this case from beginning to end in 9 months. Why not? Why not? We're under a year in the civil fraud case, which is sprawling in New York. Dozens of witnesses, a million pieces of paper. You know, $500 million in dispute, in play. Months of trial. That whole thing got filed September of last year and tried in October. So for those that don't have anything to compare it to as a comparator, this complaint that the Trump is making in every filing, that there's just not enough time, there's not enough time because we've got all these other trials, is just ridiculous. There's plenty of times. I'm going to repeat, you could try 2 Mar-a-Lago cases in the time that's left already on the clock between today and the time of the scheduled trial in May. Yes, there's a trial in March, 2 months earlier, that'll last a couple of months related to Donald Trump and something called election interference and the clinging to power and the coup that he plotted. Sure, that's complicated, but that's one defendant, 4 conspiracies, 1 defendant, and the Department of Justice. And they've already, split up the Trump defense team. Looks like John Lauro is full-time in Washington, D.C., and Chris Keiss and Todd Blanche are full-time in Florida. I don't know who's covering Georgia. They're hoping to God they don't need to do a darn thing in Georgia until the probably the spring or summer of 2024. And so they got Steve Sadow, a local lawyer, kind of running around trying to do zone defense because he's got no backup. He's got nobody helping him. They're all tied up in the other 2 cases. But that's not the fault of the prosecutors. That's the fault of the criminal, at least the indicted criminal, Donald Trump, who's indicted in multiple jurisdictions at the same time. It's not the government's problem that there's 91 total felony counts against Donald Trump in 3 different jurisdictions. That's Donald Trump's fault. And that we can't fit them all in, so many criminal trials, so little time. That's Donald Trump's fault. Some of it's going to impact his due process rights. He's going to have to scramble and hire more people. He's going to need a bigger boat. That's just the way it is. No surprise. He needs a bigger boat. He needs more people. And Judge Chutkan in the D.C. Circuit Court told him as much. She said when they were arguing, Judge, so many pieces of paper, so many, oh my God, terabytes and terabytes of data. How will we ever do it? It's like reading War and Peace every day. If you stacked it end to end, it would go to the top of the Washington Monument. They actually said this in filings. Odd choice of words, Washington Monument, the location where a lot of people who stormed the Capitol met. And the judge says, stop. She did. She said, stop in a hearing. You're acting like your client is poor, is impoverished, is impoverished. He isn't. He has money. He has lots of money. He may have less money. This is my commentary after the civil fraud case, but he's got lots of money. He can hire document reviewers and examiners, and he can hire a database and an e-discovery, electronic discovery service to look at all these documents with him. And you can get that done in record time. This isn't old-timey days like you're Abraham Lincoln, like with a gas lantern, reading by candlelight 1 page at a time. I've done terabytes of cases involving data, and you hire, 12 people at a vendor who are lawyers and paralegals who go through the documents and then tell you which ones to look at. And that's what they're going to have to do. So when you read or you hear that Donald Trump is complaining, oh my God, 167,000 pages of documents were just produced and we've only got 7 months, what do we do? That's ridiculous. And the judges know it. Maybe Cannon doesn't know it, but every other judge knows it. First of all, in the Mar-a-Lago case, the new 167,000 or whatever it is pages of documents, it comes from Walt Nauda's cell phone, which means it's text messages, which means it's been downloaded into pages of a spreadsheet, right? And like 5 lawyers over a weekend can go figure it out. That's how long it takes. And it was already produced in prior productions. So they got to, talk about grasping at straws. They just write their entire papers out of straw, right? And then Jack Smith comes in with a lighter and blows it all up. That's what we see time and time again. So when you hear big numbers like, oh my God, classified documents have been withheld since the indictment, it's 9 documents. 9. There were 30 classified documents. They've seen 21 of them. There's 9 that they're waiting for the security clearance issues and facilities to be built. Okay, good for them. Oh my God, hundreds of thousands of pages. Forget it. They've already got 1.1 million pages of documents. They're just getting a last gasp of maybe 10% more. And they will, as the government pointed out, they'll get more documents between now and 7 months from now as the investigation continues. That's what happens in trials. I've been in trials in federal court where I get handed a stack of documents like the day of the trial. During a trial day, here you go. We're going to be talking about these today in court. Sounds terrible, right? Or you find out that morning who your witness is in the afternoon for the government. Who's that guy? Grab me a legal pad. I got to do some cross-examination. I'm not kidding. That's how I prepared for hot takes. Years of doing federal criminal practice where I found out about witnesses at the last minute. So I want you to understand in this hot take a couple of things. One, the attempted delays by Donald Trump should fall on deaf ears when it comes to alien canon, but I'm not sure it will, the judge there. And we'll find out. There's no reason that this case and another identical case couldn't be tried at the same time over the remaining 7 months. That's for sure. And Jack Smith has signaled to the world that this is an obstruction case at heart, at centerpiece, not necessarily an espionage case, and that it can be proven with non-classified documents, including Donald Trump's intent and motive, which was personal and political advantage in nature. I'm going to look at these kind of filings, comb through them, look at footnotes, cross-reference cases, sly references, and then analyze them using my 32 years experience as a trial lawyer, bring them right to you on the MeidasTouch network on hot takes just like this one. I do it here exclusively. We have a podcast on Wednesdays and Saturdays called Legal AF, also only on the MeidasTouch network, where we curate the best 5 or 6 stories from the week and present it to you with a co-anchor. I got a co-anchor on Wednesdays named Karen Friedman Agnifilo, longtime prosecutor, and on Saturdays I do it with Ben Mycelis of the MeidasTouch network. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Hey Midas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.